Good morning and good afternoon, and welcome to this Revolution.Aero Town Hall special. In light of the sector's first public litigation with Archer Aviation and Wisk.Aero, which we've been following closely, today's town hall will address intellectual property, patents, and protecting ideas in aerospace innovation. It's an exciting time to be in the space otherwise, with about 400 eVTOL developers and billions of dollars in capital coming through SPAC mergers. We have three experts on the subject today. So without any delay, I'm going to invite our first speaker, Colin Schnook, who is Research and Intelligence Analyst at Lufthansa Innovation Hub.
Hi, Alistair. Good morning.
Hi, Colin. This is Yuvan. How are you doing?
I'm doing great. Thanks. How about you?
Thank you so much for joining us this afternoon. Colin, for those that aren't aware, could you please explain what Lufthansa Innovation Hub does?
Yeah, so the Lufthansa Innovation Hub is kind of the digital unit, the digital innovation unit of the Lufthansa Group. And we are looking into potential future business opportunities that are not focusing on the status quo right now, but rather on what's going to happen in, let's say, 5 to 15 years from today. And we are also the bridge between the corporate world and the startup ecosystem.
Amazing. So, Colin, right off the bat, what are your views on the Archer Wisk case?
Yeah. So first of all, I'm definitely not answering this question from a legal point of view because I'm not a lawyer here, not a patent lawyer. But I guess we have someone from Bird & Bird after me, so she will be way more qualified to answer this question. But from my point of view, if you look at one of these patents by Wisk and just compare it visually with the Archer air taxi design, then it's quite obvious that these are at least very similar. And I guess that no one actually can deny that. And also, if you take into account the background story of Archer, which makes it even more a case for Wisk, because key engineers were leaving Wisk and then transitioned over to Archer, and suddenly Archer came out of stealth mode, kind of surprised an entire industry with its very short time frame for going to market with its eVTOL aircraft compared to other players. But this case has a few implications that is quite important, I think, for the overall air taxi space and investors. And the first one is that the protection of technology in general is highly relevant, even in the space, which is still, I would say, years away from commercialization. Second, the patent dispute also illustrates that betting only on one player, let's say Archer, from a strategic partner and investor point of view, at this stage is a high risk game. And third, or lastly, this case shifted the power of negotiation away from air taxi startups, which has become weaker now, towards the outsiders, I would call. So for a strategic partner or an investor, it's now probably one of the best time to enter the space at a discount.
Amazing. So you guys have done a great report mapping the air taxi industry based on financial backing and patents. So, I mean, you touched upon it slightly, but why have you valued patents so highly in sort of the innovation, on the innovation scale?
Yeah, so from a patent point of view, patents are a great proxy of innovation, and they also possess it's a strong asset which companies or startups can use as a competitive advantage. And let me quickly give you a very concrete example. Joby Aviation, for example, has built a decent patent portfolio so far in the last 5 years. And one of their strongest patents so far is protecting a technology which reduces noise. And this noise reduction technology is one of the most, and at least from our point of view, the most important technology that's being protected by Joby besides the aircraft design itself, because reducing noise will be a critical success factor for any eVTOL player out there, because that will be that will be decisive if a player is allowed to actually fly across or land within densely populated areas. And also, if you look at the investor, like the VC landscape or stakeholders, they usually pay attention to patent rights, and if a startup has protected certain technologies that they developed, and this is especially true for technology-intensive industries, and I would call the air taxi industry to this kind of technology-intensive space. And coming back to the reports that we published at the beginning of February, where we included patent metrics in combination with funding or venture capital funding. We did this because these two metrics kind of highlight, on the one side, the technological power and relevance of a startup in comparison to its funding. So this could potentially mean that a startup which has a very strong technological relevance, but so far hasn't closed the required funding, could be an attractive investment case for an investor, for example. Obviously, this is only one part of the pie, right? So we only looked at one aspect, and obviously any investor needs to look at many other aspects like the team, the business model, and so on. But it was our aim to actually focus on the technological part and provide more clarity on this area.
Of course, I think you've answered slightly my next question, but I mean, what are some of the other factors that affect the financial backing received by developers in the space?
Yeah, one is definitely the team. The team is obviously quite important. If you have the required experience in-house, if they understand the business, that is one of the key factors. But obviously also if they can sell like their business case to the investor.
Yeah, of course. And so there's a lot of, I mean, we've been talking a lot about the blank check companies. You know, what do you think about early stage companies being backed by these blank check companies, the SPAC mergers?
Yeah, I mean, it's for these startups which are at an early stage, so they are far away from commercializing. It's probably a good way to secure additional funding because they need the capital. They need it for certification and the manufacturing of the aircraft vehicles. So it's good for them. On the other side, it's could potentially be dangerous or very risky for like a normal investor, because now even myself can purchase a share from Quell, for example, or from one of these other two SPACs, and but no one really knows are these projections, these revenue projections, will it materialize? And one thought I would like to throw in is they claim to reach, I think, over the 7 years period after earning the first revenue to earn above $10 billion US. And there's only one company so far who actually achieved it, and this was Google with 8 billion, I think it was. So that is quite ambitious, and I'm not sure if this is going to happen in the future. But nonetheless, these startups need money, a lot of money, to actually take off, and it's a good way, or one way to collect those money through this bucket.
So, Colin, the rate of change in this sector, the technology sector, aerospace, is extremely rapid. How is the Innovation Hub? How do you guys stay on top of it?
Yeah, so we have we use multiple tools to keep track of all the different happenings out there. One is, for example, it's called Feedly. It's a news tool where any kind of news or piece of news that someone within our team spots, that team member can then add it to a Feedly and tag it, for example, the air taxi space, and then everything that's discussed on the air taxi space is then assigned to one Feedly board, and then it's very easy to actually then go through and always stay on top of things. And then I'm also using various other databases to keep track on the VC landscape and also the patent landscape. So for the VC, we use either like the normal databases, Pitchfork, Crunchbase, DRoom, and for the patent overview, we use PatentSite, which is it's an easy tool to get a quick overview of the patent portfolios of these startups and companies. Then it's monitoring social media channels, what people discuss there, for example. And then obviously the most valuable part is to actually talk directly to startups like Lilium, Volocopter, Jobby, eHang, for example, and also their investors to get a better feeling and understanding of their technology, of their timeline, and so
on. Colin, I think this is a difficult question to answer, but is it too early to pick winners in this space? I mean, we spoke about the hundreds of developers in this space.
Yeah, it's a good question, and someone from within Lufthansa raised this question, I think, last week, and we did a marking of the top 10 eVTOL startups out there, or players, and we came to the conclusion that it's not the time to call out one winner, because it's not yet the case. We are in a phase where we have some very promising front runners, I would say, and one of them is obviously Jobby Aviation from the US. We have Volocopter and also Lilium, at least Lilium from a funding perspective, who are very promising, and then also players who were more reserved in the past in terms of news announcement, such as Beta Technology, for example, which we would see as front runners, but so far not like one clear winner. And I'm also not confident that there will be only one winner in the end, because there are so many different use cases, and there will be more than one player in the end covering a certain geography, having a different use case, and so on.
That's amazing. Colin, thank you so much for joining us this afternoon. Really appreciate it. Thank you. Next, we have Catherine Stevens, partner and co-head of IP at law firm Bird & Bird. Catherine is going to be joining us any minute now. Hi, Catherine. Good afternoon. Good to see you. How are you?
Very well, thank you. How are you?
All well, thank you. Catherine, would you like to quickly introduce yourself and Bird & Bird?
Yes, Bird & Bird is an international law firm. I'm a partner and I co-head the IP department here in London. I have an engineering background and consequently fell into working on patent litigation fairly early on in my career, and I have done all sorts of patent litigation, both national and cross-border. But that's not the limit of my interests. I actually have an interest in design and trade secrets, and also increasingly in the protection and commercialization of data.
That's great. Catherine, can you take us through the importance of IP generally?
Yes, so intellectual property comes in various flavors. So registered trademarks protect brands, copyright protects artistic works and software, and patents are the ones that protect ideas. And sometimes you hear the expression, the idea-expression dichotomy, and that is sort of to indicate that patents protect ideas, whereas copyright actually protects the expression of the idea. And therefore, they're sort of aimed at slightly different things. The thing about intellectual property is that it takes what are intangibles and actually protects them with the property right, which can then be licensed, it can be sold, it can be exploited, and also, of course, it gives you a monopoly which you can then assert against third parties.
And are the disputes very common?
It all depends. It does depend. It depends from country to country. Certainly in the UK, when it comes to patent disputes, we see no more than perhaps 20 or so going through to trial each year. In Germany, for example, you see 500, 600 patent cases going through to trial. And in the States, of course, it's a much, much bigger jurisdiction. And again, they have far more patent actions going on than we do in the UK.
Mm-hmm. And so what happens when someone claims IP or a similar kind of theft? What's the first step?
Well, first, just to pick you up on your word theft, that sort of suggests some sort of knowing culpability on the person who is infringing the intellectual property right. And that doesn't always happen. I mean, sometimes, yes, there has been a stealing of trade secrets, or employees have walked off with the company's trade secrets. But to succeed in a patent infringement action, you don't have to prove that there has been copying. It just might be that two companies come to the same solution at much the same time, and one was ahead of the game and patented it before the other. So you do have to be a little bit careful with throwing IP theft around the place as a concept.
And how do you defend IP? What are some of the hurdles?
The first thing, when you think that a competitor has infringed your intellectual property rights, is really to work out what your strategy is going to be. Have they in fact infringed a valid right? But more than that, it's looking at where they are doing it. So have you got a registered right in that particular country? If they are based in a particular country, then that would be the place to go. Perhaps you can stop them because they're actually using the right in another country, or they're importing it into a country. In intellectual property rights are nearly always national in nature, so you have to think about what is happening and where it's happening as you develop your strategy. The next thing is to really look at what tools are available to you in different countries and how you might play the game. Do you want to go for a seizure on an ex parte basis in a country which, like Italy or the Netherlands, which can be a very dramatic way of starting a patent infringement action? Or is none of this appropriate in this particular instance, and you want to talk first to find out whether a compromise can be reached?
Right. And so, I mean, I imagine this, taking a step back from there, what are some of the common pitfalls when the company prepares IP protection? I mean, how do you sort of prevent that kind of thing from happening?
Well, I think one of the things is you might just find that it's a bit too late to correct what's happened. but if you are on the receiving end of, say, a cease and desist letter that has been sent to you, look carefully at what you're being asked to do. Is it possible for you to work around the issue? So can you come up with a solution that is no longer infringing a right? But I would always say that it's much better to try and set up your strategy in-house so that you avoid this problem happening in the first place. So Colin was talking about doing landscaping. You can always look at what your competitors are doing and what patents they're applying for, and either challenge the patents early on in the process to try and get them invalidated, or work around them. But it's better, I have to say, to avoid patent infringement actions, because these can be very expensive if you get drawn into them.
Brings me to another question about any upsides to bringing IP litigation as the company. As the company, well,
first of all, you might have to, because your rights are being infringed, and you know, either you're going to have to put up or shut up. So you might feel compelled to enter patent the litigation. It also sends a very strong signal to the market that you are prepared to defend your patents if that is what is required of you, and there are certain benefits to doing that, because you may well be able to settle off early with one company, and then you know, you have sent a very clear signal to the market that people are either going to have to take licenses from you, or they're going to have to work around your patent portfolio.
Right. And typically, how long are cases? How long do they last? How long do they take to settle?
Again, that very much varies from jurisdiction to jurisdiction. But here in the UK, you can get a patent action on within about 12 to 18 months of issuing proceedings. In some countries, it's a bit slower. In some countries, it's a bit faster. And that is one of the things that you have to build into your strategy.
So, Catherine, this specific dispute that we're seeing, is that a sign that the industry is maturing?
This particular dispute, I've read some of the public statements about it, and I think this one possibly not, because this actually did appear to start off with employees taking trade secrets from one company to the other, and it's a trade secrets action as well as a patent infringement action. That can happen at any stage in a company's history, but certainly you do tend to get sort of waves of patent litigation. So when I started, it was very much the chemical industry that was fighting tooth and nail over their patents. Then the mobile phone patent litigation has been going on for at least 10 to 15 years now, and that's been keeping a lot of us busy. And it does, yes, if people are prepared to put the money into defending their patents, it means there is money in the business, and that does mean that there is the business is maturing.
I think final question, Catherine, how can aircraft manufacturers better protect their intellectual property?
I personally think it all starts with the employees. You have to, of course, have a contract of employment which deals with all the necessary covenants to protect the company. But more important than that, you've got to explain to the employees why intellectual property is important to the company, why keeping the company's trade secrets is important, why their innovation is important to the company, and encouraging them to put forward their ideas to be patented so that the company can grow its patent portfolio. So it's a bit of a hearts and minds job, really. And then secondly, I think having the systems in place in the company to capture the intellectual property so that when a problem does arise, you have clear record that you own the intellectual property and that you are much more able to bring a case if that is required.
That's amazing. Catherine, thank you so much for joining us this afternoon. Next, we have Christopher Cow from Pillsbury. Hi, Chris. How are you? Thanks for joining us.
Hello, Yvonne. Thanks for inviting me here.
How are you doing, Chris? Would you like to start off by just introducing yourself as well as Pillsbury?
Sure. So it's great to be here. My name is Chris Cow. I'm a IP litigation partner at Pillsbury, Winthrop, Shaw, Pittman, which is an international law firm, but I'm based in San Francisco and Silicon Valley and represent technology companies in IP litigation disputes, both trade secrets, patent, trademark, copyright. And in addition to my US-based practice, I also manage the Taipei office of Pillsbury and represent numerous clients based in Asia in US IP litigation matters.
Chris, I'm going to start you off with the question that I asked Catherine about whether disputes are very common in IP. Obviously, you have two different jurisdictions, so feel free to take whichever one first.
Yes, so IP disputes are very common in the United States, much more so than I think anywhere else in the world right now. We routinely see each year at sometimes as high as 10,000 patent litigation cases filed a year. It's now settled down to around 5,000 cases a year, but that still is a large number of cases that are filed every year in the US.
Wow. Why are you able to attribute any reasons to that?
Well, I think in general, obviously the U.S. tends to be a more litigious country than other countries, but also for I think many years now, the U.S. has been the market where most companies file their patents. That is shifting somewhat, but still, I think you'll find that most companies tend to file patents. In every company across the world tends to file patents in the U.S. just because the U.S. is one of the, and if not the largest market for most of the innovative new technologies that are being released. So if you want to protect your IP anywhere, you certainly want to protect it in the United States.
Absolutely. So what's the first step when someone claims IP? I'm gonna stay away from saying some kind of theft, but what's the first that happens?
Sure. Well, if you are accused of infringing somebody's IP, whether it be trade secrets or patents, the first thing for a company to do is obviously to perform a thorough assessment. And that can either be internal or it can be through the use of outside counsel. That's something that I do all the time. And it really requires an analysis of internally, if it's a trade secrets matter, have you had access in any way to the other company's confidential information, either because of former employees of that competitor that have come over to join you, which was an issue in the Whisk case, or through some other means. Perhaps you were working in a collaborative manner with another company, either through an official joint venture or just some partnership. You may have been exposed to confidential information that way. On the patent side, patents are not dependent on having had any access to information from a competitor. You are simply, in that case, assessing whether your products use any of the technology that is described and claimed in the patents themselves. And that's really the assessment you have to make. And in addition, it's important to actually look at whether the patent is valid. Does it claim ideas that are in fact new, or does it claim ideas that are already known in the industry, and therefore you can argue that the patent is invalid? And the same is true for trade secrets. Something is not a trade secret if it's well known in the industry, at the time. So if a competitor accuses you of infringing trade secrets, another thing to look at, in addition to access, is whether what they're claiming to be a trade secret really is so, or if it's just something that you knew and everyone else in the industry knew.
So, what are some of the hurdles to defending, something that's not commonly known, something that's not a sort of public knowledge?
So the hurdles, the major hurdle to defending one of these lawsuits, particularly if you're an early stage company, is simply the cost, right? So in the United States in particular, defending IP lawsuits is expensive. So that's just something that has to be taken into account, and can alter your strategy depending on whether you have the resources to engage in that type of litigation. But then if there is some merit to the IP claim, then you need to strategize about how to differentiate your products. Do you need to change the design of your product in any way to design around the IP that the other side is claiming you infringe? That would be the next step. And that could be costly too, right? If you have already gone down the road of one design and you're manufacturing one design, it could be costly to change all of that. But that may be the better and more cost-effective option if the alternative is being engaged in multi-year litigation in the courts where you're spending money on that rather than innovation. Right.
And so how long would a typical case take to settle in the US?
It can vary. Many cases, there's often an initial opportunity early on in a case to try to resolve things quickly, because there may be an incentive on both sides not to spend a lot of money paying lawyers to engage in litigation. So I think there's, many cases do settle early on. There's a window there. After that, there generally is, if the parties cannot resolve things early, it can be, many, many months, if not a year or more, to get to a resolution. Because if it's hard to settle early on, generally the parties will want to have some ruling in the court, not a final trial decision, but at least some interim ruling to suggest to the parties which way the case may be going, who has the better argument, in essence. So there's another opportunity sort of in the middle of the case to settle. And that if you were to go all the way to trial, in the United States, it varies depending on the venue of the case. So in the US, you could potentially file IP suits in any state in the country, depending on where the products are being sold or manufactured or designed. And in some jurisdictions in the US, in some states, IP cases can go to trial within a year to a year and a half. In other slower jurisdictions where the courts are busier, the case may take 2 or 3 years to get to trial. So there's a very wide range in the US.
Wow. So how can the aircraft developers, we're talking about hundreds of new developers, lots of attention. How can they better protect their intellectual property, their designs?
So I think for all companies, it's really important to have a good IP program in place from the outset, and one that really looks at IP from a strategic point of view, and sets the policies based on that strategy. So the mistake that I think a lot of companies make, particularly early stage companies, is that IP is sort of considered on more of an ad hoc basis. But I think it's important to set a strategy from the very beginning that includes consideration of, for example, what types of IP do you want to protect via the trade secret route versus the patent route? And there are differences. So just briefly, for trade secrets, the value, you're protecting IP from a trade secrets perspective by keeping it secret. And in order to do so, that means the company needs to install practices within the company early on to protect those secrets, meaning having the employees sign appropriate NDAs, having any visitors to the company, any vendors that you're working with to sign appropriate confidentiality agreements, limiting access to the most valuable technology and ideas that the company has to a certain number of people. You do not want to expose those ideas very widely because then you can lose trade secret protection for your ideas. As opposed to patents, where there's other IP that you might want to protect with patents. The difference with patents is you're making a bargain. For a patent, you are describing your ideas to the public. So instead of keeping them secret, you are writing them down in a patent that anyone can read. In exchange, the governments, whether it be the US government or the foreign governments where you may apply for the same patents, gives you a monopoly, essentially. For a certain number of years, you have exclusive rights to the invention that you've disclosed, and you can prevent others from using those ideas. So early on at a company, it's important to decide which you're going to protect by trade secrets and which you're going to protect by patents, and have internal protections accordingly. Just as one piece of helpful advice, if your technology can easily be reverse engineered once it's revealed to the public. In other words, if a competitor can, upon seeing your technology or purchasing it and disassembling it and reverse engineering, if that's the case, then you would rather go the patent route versus the trade secrets route, because trade secrets protection does not prevent against reverse engineering. Reverse engineering can be used, and that will be a defense to trade secrets action. Whereas a patent infringement action means no matter how your competitor got there, maybe they independently conceived of the same invention, or maybe they took your device that they reverse engineered it, you would still be infringing the patent if you were using that same technology that's covered in the patent. And so, again, at a high level, it's important to think through all of these things and establish a good IP program at the company early on, so you can make sure you're protecting all of your innovation in exactly the ways that you want to do it to protect the company and increase the value of the company.
Chris, we have some questions coming in. Jim Simpson is wondering whether NDAs are enforceable across any of these.
So yes, they are. It depends on the U.S. is a complicated country because the NDAs are generally covered under state law. So each state differs as to how strongly they enforce NDAs. But typically, for the most part, employee contracts will be enforceable with respect to confidential information, in terms of making sure that your employees cannot take that any information from your company and go to a competitor and share that with them. Those will generally be enforceable. And NDAs in the context of, or confidentiality agreements in the context of partnerships with vendors and with joint developers, those will be enforceable as well, in terms of prohibiting them from sharing the technology with some other company that they may be working with. It's a little bit more difficult with NDAs, for example, that many big companies, right, require you to sign when you go to visit their office, and you have no choice but to sign those just to enter the office. Those may be more difficult to enforce. I still think it's as a matter of practice, it's a good idea to require those, even if ultimately those may not be as enforceable. It's also good to know, though, because of that you may not want to expose anybody just because somebody comes to your campus, signs an NDA, you still may want to be vigilant, right, about what you expose that person to in your offices. If it's really very confidential information, you don't want to share that with just anyone, even if they've signed an NDA.
Great. Also, another question from Atul Kumar. How will the Whisk Archer situation set a precedent for other eVTOL companies? And is this comparative to other emerging markets? There's a second part which I'll ask you after.
Sure. So in terms of a precedent, I don't know that there's any sort of precedent that we can, discern yet, because as the case has just started. And I would also say that it is typical of IP disputes in other industries. So I don't think this particular suit is that surprising or different from suits you see in other developing cutting edge industries where I think early on, as the market shakes out in those technologies, you will see litigation like this, where competitors, either patent infringement cases, which the WISC case includes, and trade secrets issues. It's quite common. So a good example is, in the autonomous driving space, the Waymo versus Uber case, which actually resulted in, the key individual, Lewandowski, even getting criminally convicted for trade secrets theft. So that's a similar instance, a very similar case where in a developing, very hot, cutting edge industry, there are IP disputes, early on as each company tries to, establish their technology and establish their market share.
Absolutely. Second part of that question is also, could there be a consolidation in designs and companies, which I think you might have touched on, but I'll let you on.
Yeah, I think there always is, as technology matures and industries mature. There does tend to be consolidation in the industry from many hundreds or thousands of players to fewer. Simply, in part because not all of that is driven by IP, right? A lot of that is driven by business considerations. But from the IP side too, there may only be a number of different viable competing solutions from a technology standpoint, and so it is natural for there to be consolidation around those sort of the key differentiating pieces of technology, and so and standardization as well can help drive consolidation. If in a given industry there's going to be standardization of some of the technology, just so companies do not have to design from scratch for all aspects, right, of the product. There could be consolidation for those reasons too.
Great, Chris. I think final question for you: is this a sign that the industry is maturing?
So I guess I would echo what Catherine said there, and it is to some extent, right? I mean, I think once you start seeing IP litigation disputes, it means that there is enough either existing market potential or future potential in the market that companies think it is worth expending the money in litigation on, right? If there wasn't substantial business to be had, then you wouldn't bother filing IP lawsuits. So when you start seeing IP lawsuits amongst competitors, that can be an indication that the market is maturing and at an early stage. And then further down the road, that a market is very mature when not only do you see customer IP lawsuits, but you begin to see the non-practicing entities, the NPEs, and the what are known in the industry as patent trolls. Once those entities start coming in and filing lawsuits, then you have a very mature market, because they are just trying to extract any value they can get out of IP in the market. And I guess the one piece of advice or thought that I'll throw out there is, when you get to that stage, what's interesting is the IP, right, that the NPEs, the non-practicing entities, use to assert against real businesses in the market tends to be the IP from the losers of the early market competition, right? So IP from companies right now that are smaller players, if they shut down operations over time or run out of money, the patents still exist, and generally these profiteers will buy them up and hold them and wait till the market matures and then bring lawsuits based on patents that were developed by innovative companies at the time, they just lost out in the competition, and so their patents are left open, on the market. So it's one thing, if you're in this market, to think about is as you see smaller competitors, if they're failing, one thing to do may be to acquire that IP yourself, so you own it, and you cannot it cannot be used against you later. So it's something that I recommend. If you see patents come up for sale, you may want to buy them cheaply now versus get sued on them later on and then have to pay some NPE, an extortion price for the IP.
Chris, that's great advice. Thank you so much for joining this. I know it's early in the morning for you, but this has been great. Thank you so much, Chris. And thank you everyone else for joining us this afternoon as well. Just a reminder, we have our Revolution.Aero Global 2021 event from the 29th of June to the 1st of July. It's free to attend, and you can follow the registration link at the call for action button below. Thank you so much again.